I'm Drew Stevenson, and this is a video lecture for my professional responsibility class about ABA Model Rule 5.3, responsibilities regarding non-lawyer assistants. Now, for my students, this is part of a set of the model rules of professional conduct that are really about law firms and associations. And so there's a set of ethical rules that aren't just about dealing with clients or other parties or courts, but are actually about the special ethical issues with being in a firm, who's responsible for a firm's policies and conduct and compliance with the model rules by other lawyers at the firm and so forth. So keep that in mind. When I have grouped the rules together in order of how heavily tested they are on the MPRE, this is in the second half of my course. So it's not one of the most heavily tested rules, but you will encounter some questions about this on the MPRE. And these questions do come up in practice as lawyers work together, whether in a law firm or a government legal department at an agency like a county attorney's office or state attorney general's office or something like that, or an in-house legal department. So 5.3 is going, and 5.1, 5.2, and 5.3 are going to pertain to all of those settings. The other thing I want to say by way of introduction about 5.3 is that you'll notice that the language here is very similar to 5.1. The rules are, parts of it are verbatim in terms of the responsibility that lawyers have for other lawyers. And now we're going to talk about the responsibility that lawyers have for the non-lawyers who are their subordinates. And it could be people who are employees of the firm, like secretaries and paralegals, or outside vendors, like an outside investigator or a copy shop that does photocopying, or a court reporter that's hired to do transcripts of a deposition, or something like that, where the firm is hiring someone outside. So let's take a look at our slides. And so here's section A of Rule 5.3. With respect to a non-lawyer employed or retained by or associated with a lawyer, a partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm, shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that a person's conduct is compatible with the professional obligations of the lawyer. And so our first takeaway here is that you can be subject to discipline as a lawyer if you are a person who's in charge of a law office. So this could be the partner at a firm, a managing partner, or maybe you're still an associate, but you function as the office manager. Or it could be someone who's not called a partner, but they basically are the department head or general counsel at an in-house legal department. You supervise the staff in a law office. So if that's you, if you get to set the policies and protocols and training requirements for the staff who are non-lawyers at the firm, then you have some ethical duties to make reasonable efforts to give reasonable assurance that they're complying with the professional obligations of the lawyer. Now, notice we use the word reasonable twice. So first of all, this is not a strict liability rule. You're not automatically fully liable. It's not a zero tolerance rule for infractions. That the question is going to be, did you have safeguards in place? Do you have systems in place for training staff, for providing some oversight and supervision? We don't expect the partner or office manager of a firm to be hovering over every secretary or legal assistant every minute to supervise every little thing that they do. But instead, we use this word reasonable. That's kind of a hedge word, but it means that if you have accepted norms in place for the size and nature of your law office, then that will be sufficient, even if a subordinate does commit a violation despite your best efforts. The other thing to keep in mind, though, is that the big takeaway from A is that the subordinates at your firm have to follow the model rules or the your state's version of the rules as well. In other words, if a lawyer is bound by the duty of confidentiality to a client, so is your support staff. If you have duties about conflicts of interest, right, not to do things that would pit one client against another or do something that hurts the interests of one client just to advantage someone else, the support staff has that too. If you're not allowed to destroy evidence or engage in witness tampering, that's true of the non-lawyers who work for you. So make sure you understand you can't use lawyers, the non-lawyers who work for you, your paralegals, your law student interns, um, as a proxy to violate the rules, to do your dirty work for you. That's if they're acting at your behest, it's going to count as you doing it. So let's go back to our rules. Okay, B, this is 5.3b. A lawyer having direct supervisory authority over a non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And so here, instead of talking about the people who can set policies for the whole office or firm, or if it's an in-house legal department or government legal department, you're just a regular lawyer there, but you have some subordinates. You have a secretary or legal assistant or someone like that who basically is assigned to you. And so even though you might not be responsible for firm-wide system failures, let's say, or ethical violations that are unrelated to you, if you have direct supervisory authority or a direct subordinate, you do have some responsibility to ensure that that person's conduct is compatible with the ethical rules. And again, if you have a law student intern who's working for you, a paralegal who's really kind of your paralegal at the firm, then you have some supervisory responsibilities ethically to make sure that that person isn't either violating the ethical rules at your behest, like in lieu of you, or just kind of ignoring the ethical rules that you are trying to follow. Okay, C. And I had to break this one up to cover across multiple slides because it's very long and the font would have gotten too small. C, a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if, one, the lawyer orders or with knowledge of the specific conduct ratifies the conduct. So if you instruct a non-lawyer who works for you, and this could be a law student intern or a paralegal or a secretary or an outside vendor, to do something that's would be an ethical violation for you to do it, then you are still going to be responsible, even though someone else committed this sort of actus reus, because they were doing it as your agent. You ordered it, they're doing it at your behest. It's the same as you doing it. So you're not going to be able to escape disciplinary actions or disciplinary liability just because you had someone who's not a lawyer commit the ethical violations for you. And the same is true if your law student intern or paralegal or secretary comes in and says, hey, by the way, I started calling the jurors in the case and really put pressure on them, and you ratify it. By ratify, we mean you give them a high five or say good job or endorse the conduct, even though you didn't instruct it ahead of time. If you basically become almost like an accessory after the fact, you encourage the conduct and affirm it afterwards, then it counts as you doing it for the purposes of you being subject to disciplinary authority, like having your license suspended or being disbarred. Two, the second part of C is if the lawyer is a partner or has comparable managerial authority in the law firm or this law department or office in where they're employed, or you have direct supervisory authority over the person. So please note, we're basically combining 5.3a and 5.3b into here. Either you have a direct subordinate or you get to set the policies for the whole office. And you know about the conduct at a time when its consequences can be avoided or mitigated, but you don't take any remedial action. In other words, this is an ethical duty to try to control the harm, to limit the harm when you do find out about a violation, even if you didn't order it or ratify it. So you find out that somebody has embezzled client funds, has leaked confidential information, or has destroyed unfavorable documents or evidence, has done something that's an ethical violation. You're horrified. Well, now, even though you're not responsible for telling them to do it because you didn't, or ratifying the conduct because you are mad, let's say you fired the person, but you may also now have a responsibility to, let's say, to notify the affected party so that they can take measures to limit limit the harm and limit the scope of the injury that they're going to suffer, to put a freeze on accounts or notify the court, for example, that a violation has occurred so that the court is aware of it. In other words, mitigation or harm reduction measures become your ethical duty once you discover something that happened despite all of your instructions and best efforts. Okay, I'm just going to talk about the comments that I think could show up as test questions. Some of the comments to this rule, like many of the rules, merely restate the rule in other verbiage. So let's talk about some of these points that I think will be helpful for you when you take the MPRE or my exam. First, in comment 2, it points out, who are we talking about here? Lawyers employ assistants in their practice, like secretaries, investigators, law student interns, and paralegals or paraprofessionals. And so these are often just employees of the firm. And so these assistants, whether employees or even if they're an independent contractor, act for the lawyer in rendition of the lawyer's professional services. And so they are going, for purposes of whether you could be disciplined, they are your agents. And so you have to give these people appropriate instruction and training and some degree of supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose information relating to the representation. And you should also be responsible for their work product. And so you're not going to get out of something that's basically malpractice saying, oh, my paralegal drafted that, it wasn't me. Or it doesn't count. You can't skirt your obligations to provide competent representation just because you offloaded the work onto a paralegal or someone else who was working for you. But please note that the comments here single out confidentiality. And this means that you have some responsibilities to kind of coach and remind and warn and instruct everybody who works at your firm about the duty of confidentiality because it applies to them. So it's not just lawyers, but we don't want your secretary going home and posting on Facebook confidential information about the clients, or that a certain client is behind on paying their fees, or talking to other people. And so word gets out because of the non-lawyer subordinates. So you have an obligation to give them instruction and training and some supervision. And we're especially concerned about the confidentiality leaks through those subordinate non-lawyers at the firm. Other examples, in comment 3, it talks about people outside the firm that you hire. And the most helpful part is when it lists these examples, I think, and you should watch for things like this in test questions. Sometimes there are paralegals that are hired just on a contract basis from time to time when there's a lot of work, document management companies that help create and maintain databases for complex litigation, sending client documents to a third party for printing or scanning. Very common that law firms will outsource major print jobs or scanning jobs, archiving, digital archiving, and so forth. And this is a newer addition to this comment, using internet-based service to store client information, so storing things to the cloud, or using Dropbox to transfer documents during discovery, and so forth. Any of these outside services, you need to have some confidence in their security, the data security, that the workers there understand that they also can't leak client information, and so forth. So what does this mean when you use services like this outside the firm? And I think that sort of the classic textbook example is you have a major print job during discovery, and you are so you outsource it to Kinko's, right? You need to make reasonable efforts to ensure that they're provided in a manner compatible with the lawyer's professional obligations. So if a law firm is going to hire Kinko's to copy a lot of uh, client documents or documents related to the representation, you need to explain to them. So whoever is doing this print job, whoever your staff is, even if they're college kids, they need to be coached on that this is confidential. Or I want only a supervisor or manager doing this, and I want it after hours so that my clients' documents aren't spread out all over the counter where other customers can walk up and see it, or things like that. Okay, here's a review question to see if you've been paying attention. Can a lawyer be subject to discipline for failing to supervise non-lawyer subordinates at the firm? A, yes, lawyers have some ethical responsibilities to encourage compliance with professional standards by their subordinates. Or B, no, each person is just responsible for their own actions. That's supposed to be an easy question. And if you're not sure about the answer, you might not have been paying attention and you should rewatch the video. And that concludes our lecture about Model Rule 5.3.